Debt Verdict, DV005. Title, She Beat the Largest Debt Collector in America. Category, Revenge Consumer Victory. Target length, 1,200 to 1,500 words. 25 years ago, a woman in North Carolina opened a store credit card to save a few bucks on 2 TVs. That one decision turned into a 2-decade nightmare. Collection calls, threats, damaged credit, and a debt she was told she could never escape. But she didn't just fight back. She took on one of the nation's largest debt collection companies, and she won. Her case became a class action lawsuit worth $5.75 million. This is how one woman in North Carolina brought a billion-dollar debt collection company to its knees. In the early 2000s, a woman walked into an electronics store, a regional chain that operated across the Midwest and Southeast, and opened a store credit card. She used it to buy 2 televisions. It was a small purchase, a few $100s. The kind of transaction millions of Americans make every year without thinking twice. At some point, the balance went unpaid. Maybe she missed a payment. Maybe life got in the way. The details of the original default are less important than what happened next, because what happened next is a story about how the American debt collection industry turns small debts into permanent financial scars. The original creditor, the bank behind the store card, eventually gave up trying to collect. The debt was charged off, meaning the creditor wrote it off as a loss on their books. But charged off doesn't mean forgiven. It means the debt was sold. And it was sold to one of the nation's largest debt collection companies, a publicly traded corporation headquartered in Virginia that manages a debt portfolio worth billions of dollars. This company is not a small-time collection agency operating out of a strip mall. It's one of the largest debt buyers in the United States, traded on the NASDAQ with annual revenues exceeding $1 billion. Its business model is straightforward. It buys charged-off debts from banks and credit card companies for pennies on the dollar, sometimes as little as 2 to 4 cents per dollar of face value. It then attempts to collect the full amount from the original debtor. The margin between what it pays for the debt and what it collects is where the profit lies, and the profit is enormous. When this debt buyer acquired the woman's old store credit card balance, the company began contacting her. But the way it pursued collection is what turned a routine debt recovery into a federal lawsuit. According to court filings, this company engaged in practices that violated the Fair Debt Collection Practices Act, the FDCPA, codified at 15 U.S.C. sections 1692 through 1692p. The FDCPA is the federal law that governs how debt collectors can behave. It prohibits harassment, false statements, and unfair practices in debt collection. Specifically, the company was accused of filing lawsuits against consumers to collect debts that were past the statute of limitations. In North Carolina, the statute of limitations on credit card debt is 3 years from the date of the last payment or activity. After that period expires, the debt becomes time-barred, meaning the collector loses the legal right to sue for it. But this company sued anyway. Filing a lawsuit on a time-barred debt is not just aggressive, it's a trap. Most consumers don't know what a statute of limitations is. They don't know they can raise it as a defense. When they receive a court summons, they panic. Many don't respond at all, resulting in a default judgment, a court order that gives the collector the power to garnish wages, freeze bank accounts, and place liens on property. According to the lawsuit, this debt buyer systematically filed collection suits on debts it knew or should have known were beyond the statute of limitations. The company allegedly relied on the likelihood that consumers would not show up in court or would not know their rights. For this woman in North Carolina, the realization that the company was pursuing a debt it could no longer legally collect was the turning point. She decided to fight. She retained attorneys and filed a lawsuit against the debt collection company. But this wasn't just about her 2 TVs and her old store credit card. Her legal team argued that this company had engaged in a pattern of illegal collection practices affecting thousands of consumers across North Carolina. The case was certified as a class action. Class certification is a critical legal milestone. It means a judge has determined that there are enough people in the same situation, with the same claims against the same defendant, to justify a single lawsuit representing all of them. For a debt collection company, class certification is a nightmare. It transforms a single small-dollar case into a multi-million-dollar liability. The class ultimately included approximately 20,000 North Carolina residents, 20,000 people who this company had allegedly pursued with illegal collection practices, filing suits on time-barred debts, using misleading collection letters, and employing other tactics that violated the FDCPA. The debt buyer fought the case aggressively. The company had resources, a legal team funded by over $1 billion in annual revenue. But the evidence was damning. Internal records showed patterns of filing suits on debts that were clearly past the statutory deadline. Collection letters contained language that courts found misleading. The company's own data undercut its defenses. Facing the prospect of a trial with 20,000 class members and potentially catastrophic damages, the company agreed to settle. The settlement was worth $5.75 million. Under the terms, the company agreed to pay the class members and to change its collection practices in North Carolina. The settlement included both monetary relief for affected consumers and injunctive provisions, meaning the debt buyer was required to alter how it operated going forward. For individual class members, the payments varied depending on the specific harm suffered. Some received a few $100s. Others received more, particularly those who had been sued on time-barred debts and suffered credit damage or wage garnishments as a result. $5.75 million might sound like a lot of money. For this company, it was manageable, roughly half of 1% of its annual revenue. But the case had consequences that went beyond the dollar amount. This settlement put the entire debt-buying industry on notice. It demonstrated that filing lawsuits on time-barred debts was not a risk-free strategy. It showed that consumers, when organized into a class, could fight back effectively against even the largest players. And it was far from this company's only legal trouble. Over the years, this debt buyer has faced regulatory action from multiple state attorneys general and federal agencies. According to the CFPB, in 2015, the Bureau ordered this company to pay $27 million in restitution and a $7 million civil penalty for practices including collecting debts it couldn't verify, collecting incorrect amounts, and making misleading statements to consumers. The CFPB consent order also required the company to stop reselling debts and to implement new verification procedures. According to federal regulators, this company has paid tens of millions of dollars in fines and settlements across multiple jurisdictions. And yet, it remains one of the largest debt buyers in the country, purchasing billions of dollars in consumer debt every year. This woman's story carries several critical lessons. First, know your state's statute of limitations on debt. It varies by state and by type of debt. In North Carolina, it's 3 years for credit card debt. In other states, it ranges from 3 to 10 years. Once the statute expires, the debt is time-barred. A collector can still call you, but they cannot sue you. If they do sue, you can raise the statute of limitations as an affirmative defense. But you have to raise it. If you don't show up in court, the judge will enter a default judgment.